Welcome to Team Tiggio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Through Assistant District Attorney Jose Vila in person. We have Mr. Anderson appearing in person with his counsel, Amber Sherwood. We're sat here today in this matter for a plea and sentencing. The parties have reached an agreement. Ms. Sherwood, can you please state the agreement for the record?
Yes, the agreement would be to plead guilty to disorderly conduct with a domestic abuse enhancer for costs only.
All right. And we are in victims' rights compliance.
That is correct, Your Honor.
Mr. Anderson, do you recognize this document?
Yes.
Did your attorney thoroughly go over this document with you,
Yes, ma'am.
word for word?
Yes, ma'am.
And you understand everything completely?
Yes, ma'am.
Is that your signature on the second page?
Yes.
Is everything correct that is on this document?
Yes, ma'am.
And you reviewed it as well?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Did your attorney thoroughly go over with you your constitutional rights
Yes.
and you understand them completely?
Yes, ma'am.
Do you need me to go over your rights with you in any more detail?
No, ma'am, I do not.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand the state would have to prove on or around November 22nd, 2023 in Burnett County, Wisconsin, while in a private place, you engaged in either abusive, profane, unreasonably loud, or otherwise disorderly conduct, which under the circumstances tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes, ma'am.
You understand the maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both?
Yes, ma'am, I do.
Do you understand that there is a recommendation for the court to accept costs only, but I don't have to follow that?
Yes, ma'am, I understand.
And you understand that there is a domestic abuse modifier on this charge. That means upon conviction, not only will there be an additional $100 surcharge, but the federal prohibition to no longer use or possess a firearm for life.
Yes, ma'am.
Do you understand I could sentence you to the maximum penalty today if I thought it was necessary?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am, I do.
Are you admitting here today that you in fact did engage in disorderly conduct and it did involve somebody who would be classified under a domestic abuse modifier?
Yes, ma'am.
For the most part, are the facts alleged in the criminal complaint accurate?
Yes.
Ms. Sherwood, may the court use the probable cause section of the criminal complaint along with the statement made by your client to find a factual basis?
You may, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today, Mr. Anderson?
No, ma'am.
You're doing so freely and voluntarily and intelligently.
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, ma'am, I do not.
Anyone make any threats or promises to you?
No, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Has she done a good job?
Yes, ma'am.
As to count one, disorderly conduct, domestic abuse, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of that charge. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Vila.
Thank you. Thank you, Your Honor. When looking at this case, this is primarily something that started from a verbal altercation between two parties that have children in common, hence the DV enhancer. I think this is more than an appropriate resolution, whereas Mr. Anderson did not take advantage of programming. He is going to be saddled with that domestic abuse enhancer surcharge on this case. As such, he's going to have that additional monetary penalty and furthermore, that additional prohibition on firearms. His last conviction for any DV related offenses was back in 2016. That's almost a decade ago to the date. Given all these factors taken into account, I think this resolution is more than appropriate. Thank you.
Thank you. Ms. Sure.
Yes, Your Honor, we're asking that you follow the joint recommendation. Not only as Mr. Vila has mentioned, Mr. Anderson does not have a domestic abuse conviction for almost a decade. This did happen quite a few years ago. Mr. Anderson is now completely sober and is handling his life. This cost will serve as a reminder for Mr. Anderson in the future to help keep his anger in control, as well as the prohibition on firearms for life, Your Honor. We're asking that you follow the recommendation for costs only.
All right, thank you. Mr. Anderson, anything you want me to know? Want to tell me anything?
Not, well, I have taken a DV class in treatment after this happened, and I graduated all that. So I just wanted to put this behind me and move on. I'm like, I don't do drugs. I've been sober for almost a year now, and life is hard, but I can do it.
I'm not gonna lie, you don't look the best I've ever seen you. But I do know that you're going through some things and you're trying to go through and get your social security, and you have multiple sclerosis and a few other conditions that are bad. But you've been sober for a year, and that's a positive thing. It's a real positive thing. Hopefully that's going to help and get you to get your social security disability, because I think you need that. Because I want to see you look healthier. And I want to see you do better within the confines of your ability. I think that costs are appropriate. I'm only going to assess the DNA surcharge of $200 and the domestic abuse surcharge of $100 for a total of $300. You already owe Burnett County and the state a lot of money, and you've already indicated that once you receive your social security disability, you're going to get that paid off. But I don't want to have to, take a good chunk of your back pay or anything like that. It's already going to be a chunk. So that's why I'm going to waive the rest of the court costs and fees. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You're going to need to go provide your DNA to the jail before you leave for the day. They probably have it, but you just have to go see if they don't or they do. You have the ability to request it be expunged through a written letter to the Department of Justice, not to me, but to the Department of Justice. I believe that covers everything. But if you fail to pay your fines and fees and all of those things, not only will a civil judgment be entered against you, but a warrant will be entered as well, and you could sit up to 6 months. Mr. Vila, what am I missing?
I think you covered it all, Your Honor.
Ms. Sherwood?
I think you covered everything.
All right, then good luck to you, Mr. Anderson.
Thank you, Your Honor.
Thank you.
Thank you.